Everyone knew him as the man who built the world's largest online empire. But when Jeff Bezos stood up in federal court that day, he was about to reveal a secret that would shake the very foundations of American business law. Not just retail brilliance, but hidden antitrust law mastery, years of studying monopoly regulations in secret, constitutional expertise that even Supreme Court justices didn't possess. Judge Patricia Williams was about to make the biggest mistake of her judicial career, dismissing the richest man on earth as just another tech mogul trying to avoid accountability. She had no idea that standing before her was someone who understood antitrust law better than the Justice Department's own prosecutors. "Your Honor," said Bezos, his voice carrying the same calculated precision that had conquered global commerce. "Before you rule on Amazon's alleged monopolistic practices, may I present a constitutional analysis that will revolutionize how this court understands the Commerce Clause and antitrust enforcement." What happened next didn't just shock Judge Williams. It sent earthquake tremors through the entire legal establishment and changed antitrust law forever. But wait, this gets even more insane. Because what Judge Williams didn't know was that Jeff Bezos had been secretly attending Harvard law classes for 15 years under a false identity, studying with the world's greatest antitrust scholars, preparing for this exact moment when the government would try to break up his empire. The legal argument he was about to unleash wouldn't just save Amazon, it would rewrite the Constitution itself. Judge Williams's world, government power versus corporate giants. Judge Patricia Williams represented everything the progressive legal establishment believed about corporate accountability. At 58, this federal judge had built her career on one mission: taking down big tech monopolies that she believed were destroying American competition and democracy itself. A Yale law graduate with 20 years of antitrust litigation experience, Williams had been specifically chosen for this case because of her ruthless track record against corporate defendants. She had broken up telecommunications giants, dismantled pharmaceutical monopolies, and made billion-dollar corporations tremble at the mention of her name. Williams despised tech billionaires who she saw as modern-day robber barons hiding behind innovation rhetoric while secretly crushing competition and exploiting consumers. To her, Jeff Bezos represented the ultimate corporate villain, a man who had used predatory pricing, market manipulation, and monopolistic practices to build an empire that threatened the very foundations of free market capitalism. That day, she was prepared to deliver the legal death blow to Amazon's empire. What she wasn't prepared for was discovering that her target had transformed himself into a constitutional law weapon specifically designed to destroy her case. Bezos's hidden journey. From garage startup to legal mastermind. The world knew Jeff Bezos as the ultimate entrepreneur, the man who started Amazon in a garage and built it into a trillion-dollar empire that touched every aspect of modern life. From books to cloud computing, from space exploration to media domination, his business genius was undeniable. But what the world didn't know was that Bezos had been fighting a secret war on a completely different battlefield, the world of constitutional law and antitrust regulation. Starting in 2008, when the first antitrust whispers began surrounding Amazon, Bezos made a decision that would change everything. Instead of just hiring the best lawyers money could buy, he would become one of them. But not just any lawyer, he would become the world's greatest antitrust expert. "If the government wants to use the law as a weapon against innovation," he had told his closest advisor Mackenzie Scott during their divorce proceedings, "then I need to master that weapon better than they do. I need to understand not just what the law says, but what the Constitution really means." Under the assumed identity James Patterson, Bezos began auditing courses at Harvard Law School. He studied with Professor Einer Elhauge, the world's leading antitrust scholar. He completed advanced seminars with Professor Lawrence Lessig on constitutional interpretation. He even co-authored anonymous papers on Commerce Clause jurisprudence that were published in the Harvard Law Review. For 15 years, while building Amazon into a global empire during the day, Bezos spent his nights becoming a constitutional law scholar. He memorized every Supreme Court antitrust decision since 1890. He studied the original intent of the Commerce Clause. He understood the economic theories behind antitrust law better than the economists who created them. By 2023, when the Justice Department finally brought their monopolization case against Amazon, they thought they were facing a businessman. In reality, they were about to confront the most prepared legal defendant in American history. The case: United States versus Amazon, the ultimate showdown. The federal courthouse in Washington, D.C. had never seen a case with such enormous implications. The Justice Department, led by their most experienced antitrust prosecutors, was seeking to break up Amazon into separate companies, arguing that the tech giant had violated every major antitrust law through predatory pricing, exclusive dealing arrangements, and market manipulation. The case was being watched by every major corporation in America, every small business owner, and every consumer who had ever clicked Add to Cart. If the government won, it would establish that successful companies could be punished simply for being too successful. If Amazon won, it would confirm that innovation and efficiency were more important than traditional antitrust concerns. Judge Williams had already signaled her hostility toward Amazon through pretrial rulings that favored the government at every turn. Legal experts predicted that Bezos would rely on his expensive legal team while making brief scripted appearances to minimize damage. They had no idea what was coming. It was the courtroom setup, David versus Goliath, or so they thought. The packed federal courtroom buzzed with anticipation as the most important antitrust case in decades was about to begin. At the government's table sat the Justice Department's A-team, lead prosecutor Sarah Martinez, a Harvard law graduate who had never lost an antitrust case, flanked by 12 of the department's most experienced lawyers. At Amazon's table sat Jeff Bezos himself, dressed in a simple navy suit, flanked by only 2 attorneys from the white shoe law firm Gibson Dunn. The disparity was intentional. Bezos wanted to appear as the underdog fighting against government overreach. Judge Williams looked down at Bezos with barely concealed contempt. Here was the man she believed had manipulated markets, crushed small businesses, and accumulated more power than any individual should possess in a democratic society. "Mr. Bezos," Judge Williams began, her voice dripping with disdain, "this court is prepared to hear the government's evidence that Amazon has systematically violated federal antitrust laws through predatory pricing, market manipulation, and monopolistic practices. I trust you understand the gravity of these charges and the potential consequences for your business empire." The question was clearly designed to intimidate. Williams expected Bezos to defer to his lawyers or offer some weak corporate defense about innovation and consumer benefits. Instead, Bezos stood up with a slight smile. "Your Honor, I understand the gravity perfectly. But before we proceed, I believe this court needs to understand something fundamental about the constitutional framework governing federal antitrust enforcement, specifically the original meaning of the Commerce Clause and how modern antitrust interpretation has exceeded constitutional boundaries." A murmur of surprise rippled through the courtroom. This wasn't the response anyone had expected from a tech CEO. Judge Williams frowned. "Mr. Bezos, this court is not interested in constitutional lectures from businessmen. We're here to determine whether Amazon has violated clearly established antitrust laws." "Respectfully, Your Honor," Bezos replied, his voice gaining strength, "those clearly established antitrust laws exceed the constitutional authority granted to Congress under the Commerce Clause, and I'm prepared to prove it." The legal earthquake begins. What happened next would be replayed in law schools for decades. Bezos didn't just challenge the government's evidence, he challenged the constitutional foundation of modern antitrust law itself. "Your Honor, the Sherman Antitrust Act of 1890 was based on Congress's power to regulate interstate commerce, but the Supreme Court's interpretation of this power in cases like Wickard v. Filburn has expanded federal authority far beyond what the Constitution's framers intended." Judge Williams leaned forward, her skepticism turning to genuine interest despite herself. "Continue, Mr. Bezos." The framers understood commerce to mean trade and transportation between states, not the broad economic regulation that modern antitrust law encompasses. When the government argues that Amazon's business practices constitute restraints on trade, they're using a definition of commerce that would have been unrecognizable to James Madison or Alexander Hamilton. Prosecutor Martinez jumped up. "Objection, Your Honor. Mr. Bezos is not qualified to offer constitutional interpretation." "Actually," Bezos said calmly, "I hold a Juris Doctor degree from Harvard Law School, which I completed under an assumed name over the past 15 years. I've also published extensively on Commerce Clause jurisprudence in the Harvard Law Review." The courtroom exploded. Reporters frantically typed on their phones. Judge Williams banged her gavel for order. This was no longer a simple antitrust case. It had become a constitutional crisis. The hidden law degree bombshell. "Your Honor," Bezos continued as the courtroom settled, "I can provide documentation of my legal education if needed. For the past 15 years, while building Amazon, I've also been completing one of the most comprehensive legal educations in American history." Judge Williams was speechless. Never in her career had she encountered anything like this. "Mr. Bezos, are you seriously claiming to hold a law degree from Harvard?" "Not claiming, Your Honor. Proving." Bezos nodded to his attorney, who handed him a folder. "Here is my official transcript, signed by Dean John Manning himself. I completed the program under the name James Patterson to avoid publicity. My thesis on constitutional limitations on federal commerce power received the highest honors in Harvard's history." The documents were authentic. Judge Williams examined them carefully, her expression shifting from skepticism to amazement. "This is unprecedented." "What's unprecedented, Your Honor, is that we're finally going to have a constitutional challenge to antitrust overreach argued by someone who understands both the law and the economic realities of modern business." Prosecutor Martinez was frantically whispering with her team. Their entire strategy had been based on facing a businessman, not a constitutional law expert who had spent decades preparing for this exact confrontation. The constitutional masterclass begins. "Your Honor," Bezos continued, "the government's case rests on a fundamental misunderstanding of both constitutional authority and economic reality. They argue that Amazon's success constitutes a monopoly that harms competition, but they can't explain how consumers paying lower prices and receiving faster service are being harmed. The Sherman Act," he continued, "was designed to prevent genuine restraints on trade, cartels, price-fixing conspiracies, and artificial market manipulation. It was not designed to punish companies for being more efficient than their competitors." Judge Williams found herself genuinely engaged with these arguments. "How do you respond to the government's evidence of predatory pricing?" "Your Honor, predatory pricing is an economic impossibility in competitive markets. No company can sustain below-cost pricing long enough to drive out all competitors and then raise prices without attracting new competitors. The government's predatory pricing theory requires consumers to be stupid and entrepreneurs to be cowardly, assumptions that insult American intelligence and ambition." The economic constitutional framework Bezos then presented the most sophisticated economic analysis Judge Williams had ever heard in her courtroom. "Your Honor, the Constitution grants Congress power to regulate interstate commerce to prevent states from imposing trade barriers on each other. The framers wanted a unified national market where goods and services could flow freely across state lines. Amazon has created exactly what the framers envisioned, a truly national marketplace where a small business in Montana can sell to customers in Florida without facing artificial barriers. The government wants to break up this system and return to the fragmented markets that the Commerce Clause was designed to prevent." Judge Williams was taking detailed notes. "But what about Amazon's market power? Doesn't that concern you?" "Your Honor, Amazon's market power comes from providing superior service to consumers. We don't prevent competitors from existing. We challenge them to do better. That's how free markets are supposed to work." The constitutional knockout punch. Bezos was just getting started. His next argument would completely demolish the government's case. "Your Honor, I want to address the fundamental constitutional question that this case presents. Does Congress have the authority under the Commerce Clause to break up successful companies simply because they're successful? The answer is clearly no. The Constitution protects private property rights through the Fifth Amendment. The government cannot take private property except for public use and with just compensation. Breaking up Amazon would constitute a taking of private property, my property, without compensation and without any legitimate public use. Prosecutor Martinez tried to interrupt. Your Honor, antitrust enforcement is not a taking. Actually, Bezos cut her off, it is exactly a taking. You're forcing me to give up control of the company I built, dividing my property among artificial entities, and doing so not for any legitimate public purpose, but because you disapprove of my success. Judge Williams was struggling to find flaws in this argument. But Mr. Bezos, antitrust law has been accepted for over a century. Your Honor, slavery was accepted for over 2 centuries. The fact that something has been accepted doesn't make it constitutional. The Supreme Court has never directly addressed whether antitrust breakups constitute takings under the Fifth Amendment because no defendant has ever been prepared to make this argument properly. The government's defense crumbles. Prosecutor Martinez was sweating. Her entire case was falling apart under constitutional scrutiny she had never anticipated. Your Honor, she tried desperately. Regardless of Mr. Bezos's legal education, the fact remains that Amazon has harmed competition through monopolistic practices. Prove it, Bezos responded immediately. Show this court one consumer who has been harmed by lower prices, faster delivery, and better selection. Show one competitor who is prevented from entering the market by government regulation rather than their own inability to serve customers better. The fact is, Your Honor, the government's case is based on protecting inefficient competitors from having to compete, not on protecting consumers from actual harm. That's not what antitrust law was designed to do, and it's not what the Constitution allows Congress to do. The constitutional revolution, Bezos's final argument, would change antitrust law forever. Your Honor, I'm asking this court to do something that should have been done decades ago. Apply the Constitution to antitrust law. The Commerce Clause grants limited power to Congress. The Fifth Amendment protects property rights. The Ninth Amendment protects individual liberty. Modern antitrust law violates all 3. I'm not asking this court to eliminate antitrust law. I'm asking this court to restore antitrust law to its constitutional boundaries, preventing genuine restraints on trade while protecting the property rights and economic liberty that make American prosperity possible. Judge Williams realized she was witnessing legal history. Mr. Bezos, if I accept your constitutional arguments, the implications extend far beyond this case. Exactly, Your Honor. This case is about whether America will remain a country where success is rewarded or punished, where innovation is protected or prosecuted, where the Constitution means what it says or what politicians want it to say. Judge Williams's historic decision, weeks later, Judge Williams issued a 67-page decision that would be studied in law schools for generations. Not only did she dismiss all charges against Amazon, but she declared key provisions of modern antitrust law unconstitutional under the Commerce Clause and Fifth Amendment. This court finds that Mr. Bezos has presented compelling constitutional arguments that have never been properly addressed by American courts. The government's attempt to break up Amazon exceeds congressional authority under the Commerce Clause and violates property rights protections under the Fifth Amendment. More remarkably, she continued, this case demonstrates that constitutional expertise can emerge from unexpected sources and that practical business experience can enhance rather than diminish legal analysis. Mr. Bezos has contributed meaningfully to constitutional jurisprudence through his unique combination of legal scholarship and entrepreneurial experience. The aftermath: a legal revolution. The Bezos decision sent shockwaves through Washington, Silicon Valley, and law schools across America. Constitutional scholars praised the ruling as a landmark restoration of property rights and constitutional limits on government power. The Justice Department immediately appealed to the Supreme Court, setting up what legal experts predicted would be the most important constitutional case in decades. For Bezos, the victory was more than legal. It was personal vindication of his belief that success through innovation should be celebrated, not prosecuted. "I didn't spend 15 years studying constitutional law to avoid accountability," he said in his only interview about the case. "I did it to restore accountability, to hold the government accountable to the Constitution that limits its power." The long-term impact. The constitutional precedents established in United States versus Amazon influenced business law for years afterward. The decision's framework for protecting entrepreneurial success within constitutional boundaries became a model for courts addressing business regulation and constitutional law. Most importantly, the case demonstrated that constitutional expertise could emerge from business experience, and that the most meaningful constitutional arguments often came from those who understood both constitutional principles and economic reality. Jeff Bezos had proven that true constitutional advocacy requires combining practical experience with rigorous legal scholarship, and that protecting economic liberty demands the same constitutional courage that has always been necessary to defend fundamental rights. If you found this incredible fictional story of constitutional business courage and hidden legal brilliance mind-blowing, smash that like button and subscribe to our channel for more amazing tales of unexpected expertise challenging government authority. Hit that notification bell so you never miss these extraordinary fictional stories of how constitutional knowledge and business innovation can combine to protect economic freedom. What did you think of this fictional portrayal of Bezos's constitutional expertise? Drop your thoughts in the comments below and let us know which billionaire's hidden legal genius you want to see next. Important note: this is a completely fictional story created for entertainment purposes. Any resemblance to real events or persons is purely coincidental.